Okay. Gene, let me ask you here. What do you make of what is going on here with regard to all of this testimony about when, how, the shots, what they conscious, not conscious? What's going on here?
Well, just based on my experience, they're not trying to get an acquittal on the main count. It's pretty obvious that 16 shots into a human being, most of them when he's on the ground, that's not a good fact pattern to defend. But there are all these aggravated accounts, one for each bullet. And I think what they're trying to say is the first bullet may have killed him, the second bullet may have killed the victim, Mr. McDonald, but bullets 3 through 16 didn't do anything. So that's what they're trying to do, get the jury to at least come to a conclusion that for the other counts, other than the first 2 bullets, those other counts for those bullets, maybe a hung jury and acquittal. I did want to comment on this. On the cross-examination by the prosecutor, and we kind of chatted a little bit about it. I had a lot of trials, of course, and I made a lot of mistakes, and one of them is this. Your demeanor and your tone and your voice and your expressions in front of the jury when you're crossing someone who is not on your side can be very negative or powerful depending on how you approach it. I'm a Monday morning quarterback, and I never throw an interception. I think the prosecutor got a little too heated with that expert witness and let that witness just run and run and run with her words. Here's my approach to cross. If you're a prosecutor, keep it simple, short questions. You have 3 or 4 points you want to make, and sit down. That cross should have been 15 minutes. And what you do in closing is you remind the jury of what your short cross was, and you even say to the jury, members of the jury, my cross wasn't very long. Why? Because with all due respect, what their expert said made absolutely no sense. Here are the 3 reasons why. She didn't do that. I'm a Monday morning quarterback. I don't throw interceptions. I feel for her because the stress of that trial is enormous, and I could see the frustration on that prosecutor because I have been there and I did the same thing.
Yeah, those are excellent trial points, and they're very much up the alley of what I was saying to our viewers before. Sometimes the tail can wag the dog. If you jump into that cage and you start wrestling with an expert, get to your points short, quick. And another technique I'll just add to yours, and I think everything you said is right on the money, is it's an opportunity for you to kind of narrate your medical testimony or your case through that witness where you don't even care if they say no 50 times. It just gives you an opportunity to say it again. What are your thoughts on that?
Absolutely. When you are doing a cross, Bob, and you know this, you are the focus. So your questions become testimony. Even though there's a jury instruction, your questions are testimony. And I don't care what that witness says, the jury's going to think about what you said. Mm-hmm. And what happened with the prosecutor is she asked a lot of open-ended questions, and I didn't time it. There was one answer by that expert that was like 4 minutes, and I'm going, holy cow. Yeah. You don't have to yell. It was painful to watch, but I got to say this, Bob. I have done the same thing. I can think of a cross-examination I did in 1991 that was so horrendous, and I'm now 62. That's the way it is. It's very hard to do a cross of their expert. Here's the last point. You can never outsmart an expert. Yep. Because experts are always smarter than you. And what you do is you focus in your cross on simple LeBron James layups, things that they can't possibly dispute, and then you move on.
Absolutely. That's my analogy, but not getting in the cage with the bear because they will tear you up. And I noticed the same exact thing you did, that open-ended question where you allowed that witness now to become a professor in front of the jury as opposed to scoring points. Gene Rossi, this is why we love having you here. You could hit the 40-point game, the 41-point game. You're hitting the 45-point game here on the Law&Crime Network. You're the best. Listen, we got to go to one more thing, Gene, because kind of consistent with what we're saying is how they're tying in the paramedic testimony to the actual forensic pathological testimony as well. We're going to look at one more clip, and I can't wait to come back with Gene and get his thoughts because he is the real deal. We'll be right back on the other end of the clip. Okay, so there is the prosecutor asking the pathologist as to the cause and manner of death. And obviously, Gene, as we were talking before, they're asking the ultimate questions that they want to hit with respect to not only the murder charge, but all of the aggravated assault counts, which is the 16 shots, each shot counting for an aggravated assault charge. And the question was, you could tell they were almost prepared questions, read word for word. That's not an uncommon thing for prosecutors to do, to make sure that they really hit those points, that he was alive for each of the gunshots and that each of the gunshots accelerated his ultimate demise. Was she effective?
I thought she was very effective. And you're right, it was a simple, direct. I thought she was a very terrific witness, very effective, and I think it was simple. And in any trial, you keep it simple, and each bullet by itself at that moment did not kill him, and each subsequent bullet helped kill him. That's it. You are guilty. If that's a fact scenario, you're guilty. But the first bullet didn't do it. The fifth bullet didn't do it alone. The 15th bullet, the 16th. And if you get that across, guilty on all counts.
Yeah, you know, me and you have been around the block. I mean, I've been with some great experts, ballistic as well as forensics. I mean, to be sitting there with the specificity of which bullet hit when, how, where, which one ultimately killed them is, to me, a virtual scientific impossibility.
Well, I'm going to give you a prediction. The jury is probably going to do this. They're going to find him guilty of either murder or manslaughter. And on the aggravated counts, there's 16, of course, they may either be hung or acquittal, because I believe this. If the defense puts up a reasonable, respectful fight for their client, even if the jury finds him guilty, they're going to throw, I hate to use the phrase, T-ball trophies to the defense, just to say, hey, you did a great job. We think he's guilty, but, you know, we're only going to find him guilty of 8 of the 16 aggravated. And that's probably what's going to happen.
Right, that's an excellent point, again, from a very skilled trial attorney such as yourself, Gene, because many times juries will do compromise like that in the jury room. Of course, it's dependent on each case and how well the lawyers put it in. Guys, you're at the Law&Crime Network. We are really killing it today. Are you liking it now? We'll be back on the other end of the break. I have Gene Rossi with me. We're just going to break this down a little bit. So, Gene, this apparently is another incident that occurred, I believe it was like 2013. Joseph Plaut is a Cook County sheriff. He's been called by a sheriff's officer, called by the defense in this case, talking about a violent, quote-unquote, incident. Before we get to the actual substance of it, it's always uncomfortable when a cop is testifying against the prosecution's case, because they're supposed to play together. And you could be assured, tell me if it's different in your experience, that the prosecutors none not too happy about that.
I'll give you a good example. In April of 1997, I had a drug case against 2 defendants, and a character witness was called for the defense, and it was a sheriff, a deputy sheriff. And the character witness was called to basically say that one of our cooperators was a pathological liar. We didn't really like that, and whenever a law enforcement official testifies for the other side, they have the right, they have the privilege of calling them, but it doesn't make the prosecutor feel any good at all, and it doesn't make their law enforcement colleagues feel good at all either. But it is uncomfortable for the person testifying. I can guarantee that.
Yeah, and a lot of times the defense are deprived of witnesses that could be vital in their case because of that pushback. I love having you on, Gene, because you always got the cases, the real deal here. But we got to take a break. We're going to come back in the end with more Law and Crime. Stay tuned. Okay, welcome back to Law and Crime Network. Gene Rossi, my man, you have tried so many jury trials, as I have as well. And I want to ask you, the kind of testimony that's going out, it's going in my ear, it's going out there, it's all over the place. But in any event, this is like a reverse 404. And some people in the chat room are talking about this. And this is where the standard is less to introduce it, as opposed to when you're introducing bad character evidence or other act evidence, as they call it, against the accused. The standard's different. It's just relevance in most places and by a mere preponderance of the evidence. What are your thoughts?
I totally agree. And I will say this from a strategy point of view. I don't know if this incident is something that's going to be a home run. You brought up something when we were listening. I wonder if the defense is putting on an expert on PCP, and here's why. You're trying to show that this victim, Mr. McDonald, was a crazed human being who could come at you at any moment like a tiger. And you brought up that he kind of went for his waist when he was on the ground. I did a lot of drug cases, and I interviewed a lot of drug dealers who were cooperators, and here's what they all told me. Crack, cocaine, marijuana, heroin, they didn't do a lot to me other than get me high. But when I took PCP, I became a monster. Mm-hmm. And I would have called, I don't know if they are or have, I'd call an expert on PCP to say that when a human being has PCP in their system, and I get out the amount, you don't know what that person is going to do. You don't know if that person is going to charge you with a knife, which he had. It may not have been open, but at least it will mitigate what appears to be on the video to be a pretty bad act by the police officer. Now, going back to this incident, it doesn't move me because it's probably an altercation in jail. Someone said, you know, your mother's not, you know, a saint, or said something about your girlfriend. Who the heck knows what it was about? But he had an incident, he got rowdy, and they had to handcuff him. Whoop-de-doo. That happens all the time.
Gene Rossi, listen, you have the tremendous trial experience. I love having you on. I love being on the network and hosting, but unfortunately, our time together and my time today is over. We are...
No.
Yeah, unfortunately, but you're throwing up the great shots. Appreciate it. Hey, listen, this is the Van Dyke trial. We have Carissa Krantz is coming next. She's awesome. She'll be taking it from this point forward. I'll see you guys on Wednesday between 12 and 3. Have a great week.